So let's now go to our next topic, which should be topic 5. Topic 5. And this one is called share capital. This one is called share capital. That is our topic number 5, which is called share capital. It's called share capital. It's called share capital. And we begin to write this, that share capital of a company, share capital of a company refers to the amount invested. Refers to the amount invested in the company, the amount invested in the company for the company to carry out its operations. For the company to carry out its operations. The share capital can be altered subject to certain conditions. It can be altered subject to certain conditions. Share capital is categorized as follows. Share capital is categorized as follows. So that's the meaning of share capital. It is simply the amount of money that has been invested or is expected to be invested in the company for the company to be able to undertake its operations. That's all that we mean by share capital. And we are saying you can alter. Obviously, we have been looking at alterations of various documents in a company, and we have seen that they are subject to some conditions or restrictions. Now, we want to look at some types of share capital, but they are not really types. I would prefer even to call them various names that are used to describe capital. Yeah, various names that are used to describe capital. So there are several of them. Number 1 is called nominal. Nominal stroke authorized. Nominal stroke authorized. We write that this is the maximum number of shares. This is the maximum number of shares the company is authorized to issue. Company is authorized to issue at the nominal value of each share. At the nominal value of each share. Yeah, that's what we call nominal. Number 2 is called issued. Number 2 is issued. Issued. And write that this is the amount of nominal capital. This is the amount of nominal capital that has been issued in return for cash. That has been issued in return for cash or transfer of a non-cash asset. Or transfer of a non-cash asset. Number 3, called up. Called up. Right, that this is the aggregate. This is the aggregate. Aggregate of the calls made on shares. on the calls made on the shares, whether or not the calls have been paid. Whether or not the calls have been paid. Together with any share capital paid up. Together with any capital paid up without being called. Without being called, and any share capital to be paid on a specified future date. To be paid on a specified future date under the articles. So we have just looked at calls na tumesema a call is a request that you pay some amount. So when we are talking of the call down, we are talking of the total. The word aggregate means total. So all what has been called, whether it has been paid or not yet paid. And then it also includes any other money we had received without a call. Any other money we had received without a call. The third component of this is any money we expect to receive in future without making a call. And why we shall not make a call is because the date of payment is already specified. So whoever is responsible knows that in such and such a date in future time, this is the amount of capital that I'm supposed to pay. So we don't have to call, we don't have to remind. So those are the three components of the called up capital. Then number 4 is paid up. Paid up. Paid up. This is the sum of payments received. This is the sum of payments received by the company in regard to share capital. Regard to share capital. Uncalled. Number 5 is uncalled. Called. This is the difference between. This is the difference between the amount already paid up. Difference between the amount already paid up and the total nominal value. And the total nominal value of the issued shares. The total nominal value of issued shares. Number 6 is called reserve. Number 6 is called reserve. Right. This is a guaranteed fund. This is a guaranteed fund made permanent. Is a guaranteed fund made permanent by an irrevocable special resolution. By an irrevocable special resolution. Irrevocable special resolution that it shall only. That it shall only be called up. Shall only be called up in the event of winding up. In the event of winding up. In the event of winding up. Number 7 is unissued. Unissued. And write that this is the portion of nominal capital. This is the portion of nominal capital not yet taken up. Not yet taken up by the shareholders. Not yet taken up by the shareholders. So those are the common types of share capital, or those are the common words that you will find being used to describe the share capital, depending on where we are, obviously between having asked guys to take up the shares and having asked guys to pay the amount of money they are supposed to pay. So to Mesema, we have nominal, we have the issued, we have the called up, we have the paid up, we have the called, we have the reserve, and we have the unissued. Good. Let's now look at raising of share capital. 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 And write that the company can prepare an initial public offering. The company can prepare an issue public offering, brackets IPO, initial public offering, IPO, if the company is not yet listed on the stock exchange. If not listed on the stock exchange, first. The amount of money raised, from the IPO, is highly dependent on the perceived value of the company. Is highly dependent on the perceived value of the company. Perceived value. Yeah, so what you're saying is if you want to raise capital and you are not yet listed in the stock exchange, you can do what we call the IPO. Of late, we have not had many, but if you can remember in the near past or in the mid past, we had the IPOs from Safaricom, the IPOs from the Kengen, and so on. And one of them was Safaricom that brought a lot of interest, and people really subscribed. It was highly oversubscribed. Why? Because the perceived value is high. So that is what determines how much people bring. The other point is, if a company is already listed on the stock exchange, if a company is already listed on the stock exchange, the company can, semicolon, point number 1, round an additional share issue. Round an additional share issue known as seasoned. Equity offering. Seasoned equity offering. Into brackets SFO. So now, kama you are not listed, the first one you do is called initial public offering. But when you are already listed, like now in a Safaricom and the others that are in the stock exchange, they can round additional, do a program we call seasoned equity. The season that has been there. Something seasoned is something that has been there. Number two is do a rights issue. Do a rights issue. Do a rights issue. That is, permit existing shareholders. Permit existing shareholders. Permit existing shareholders to purchase a designated number. To purchase a designated number of new shares. Of new shares at a specified price. At a specified price within a specified time. Specified price within a specified time on a pro rata basis. On a pro rata basis. First of all, the right, we are still on the same point. The right may be transferable or not transferable. Be transferable or non-transferable, and is subject to the following conditions. And is subject to the following conditions. Subject to the following conditions. Number one, articles of association must authorize. Articles of association must authorize. Articles of association must authorize. Number two is nominal capital. Nominal capital must be sufficient. Nominal capital must be sufficient. Number three is the board must recommend. The board must recommend. The board must recommend. Number four is that it must be authorized at ordinary general meeting. It must be authorized at ordinary general meeting by an ordinary resolution. By an ordinary resolution. The last one is that it must be okayed by Capital Markets Authority. It must be okayed by Capital Markets Authority. So those are the two ways in which a company that is already listed in the stock exchange can be able to raise capital. Can be able to raise capital, and we are saying number one, they can do the season, and number two, they can do a rights issue. Now, this is where you allow your members to buy some extra shares, obviously depending on the current shareholding. That's why we are saying it will be done on rata. And for you to do this, these conditions must be present. The articles must authorize. You must have nominal capital that is sufficient. You have not issued out the entire nominal capital. So this rights issue that is being offered, it is coming from the nominal capital that is not yet issued. And the board must recommend. The meeting must be there. Ordinary meeting, ordinary resolution. Ordinary is the one that requires just simple majority. And Capital Markets Authority must authorize. The most recent company to do this was TransCentury. The company known as TransCentury. I think they closed towards the end of last month. That's when they had this offer of rights issue coming to an end. Let's now look at methods of public issue. Methods of public issue. Methods of public issue. Methods of public issue. You want to issue shares in the public. What are the methods? Number one, pricing. Pricing. And we explain, the company arranges with a broker. The company arranges with the broker to sell on its behalf. To sell shares on its behalf. To sell shares on its behalf. Number two, offer for sale. Offer for sale. Offer for sale. The company sells some of its shares. The company sells some of its shares to a financial institution. To a financial institution known as issuing house. To a financial institution known as issuing house, which then sells, which then resells, which then sells or sells the shares to the public. Which then sells the shares to the public. Number three is called prospectus issue. Prospectus issue. Prospectus issue. Stroke direct offer. Direct offer. Prospectus issue. Stroke direct offer. And right, that the company sells shares directly to the public. The company sells shares directly to the public. Number four is offer by tender. Offer by tender. Offer by tender. Company invites bids. The company invites bids from the public. From the public. And the highest bidder gets the shares. And the highest bidder gets the shares. Number five is bonus issue. Bonus issue. Right. This is where shares are given to shareholders. Shares are given to shareholders free of charge. Shares are given to shareholders free of charge instead of paying dividends. Instead of paying dividends, or as a way to capitalize a premium account, or as a way to capitalize a premium account. Full stop. Bonus issue is guided by conditions. Similar to those of a rights issue. Similar to those of a rights issue. So we are saying when you have decided now to issue shares, whether you are an existing company or as in you are already listed in the stock exchange or not, there are those 5 ways. One is that you can place the shares. This is where you contract a broker to do that on your behalf. The second one is what you are calling offer for sale. This is where now you offload your shares to a financial institution, maybe a bank or whichever other financial institution, which is known as issuing house, at least for that purpose. They sell, they buy from you, so they pay you directly. Then they sell the shares to the public. The other one is prospectus issue or the direct offer. And this is where you now sell to the public. And obviously there will be maybe some involvement of brokers here and there as you do this. The other one is that you sell by tender. It's where you invite guys to bid. And then, as we know in the rules of tendering, the highest bidder gets the item. Then we have the bonus. This is where you give them free shares. So at this point, they are not bringing. But I keep on telling you people that in this world there is nothing for free. And anytime you see that you are receiving something for free, it is either you already have paid for it, but you don't know, or someone else has paid for you, or time to pay has, or rather time to pay will come. So there is nothing for free in this world. So these so-called bonus issues, they are shares that are given to the shareholders without being asked to bring any money. But it is being done to avoid paying dividends. So the money that they would have been paid, we do not pay them, but we instead give them what? Shares. So it is not for free. It is actually their dividend. Or it is a way of capitalizing premium account. The other day when we were talking about how you can sell shares, we said there are 3 prices. You can sell at the market price, you can sell at the premium, you can sell at the discount. And we say discount is already prohibited. Now, premium is where you sell at a price above. Now, because if you sell at above, at the end of the day, you will exceed the nominal authorized. So what is required in the course of time, you must get a way of recovering that excess. And that is covered by issuing some more shares now free of charge. That's called capitalizing the premium account. And we have said the bonus shares are guided by the same conditions like we noted in the case of rights issues. Let's proceed on and look at the prospectus. Prospectus. The prospectus. The prospectus. Prospectus and write that. This is a document. This is a document. Okay, so we are saying that this is a document which invites the public, to subscribe to the shares, or debentures, the shares or debentures of a public company, and it spells out, the advantages to accrue, from investing in the company. The date of publication must be shown. Full stop. Other characteristics include semicolon and number 1, described or issued as a prospectus. Number 2, an invitation to the members of the public. Number 3, an invitation to treat. Not an offer for sale. So that is what we call a prospectus. It is a document that is inviting members of the public to subscribe or to buy shares or even debentures of a public company. And this prospectus must also spell out some advantages that you get to you when you invest in this company. And we are saying that the date of publication must be included. And other characters that must be noted are: number 1, this document must be described as a prospectus. So the content, the details must be very clear that this is a prospectus. It is not any other document. It's not a share warrant. It is not a certificate. It is not any other document. It is a prospectus. And it must also be issued as a prospectus. That means the procedures that are supposed to be followed when issuing a prospectus should be followed. We should not follow the procedures like when we are issuing a share certificate. It must be issued as a prospectus. And then it must be very clear that it is just an invitation to the members of the public. And it is an invitation to treat. That means the company is not bound. It's not an offer for sale. The company is not guaranteeing that if you have satisfied all these conditions, we must sell to you. No. It is just an invitation to treat. From your commercial law, I hope you remember the meanings of that. Now let's look at form and contents of the prospectus. Form and contents. Form and contents of a prospectus. Form and contents of a prospectus. So there are 12 or so items. So we just list them. Number 1, particulars of signatories to the memorandum. Particulars of signatories to the memorandum. Number 2, number and classes of shares. Number and classes of shares. And the extent of interest. at the extent of interest of the shareholders. Number 3, rights regarding capital and dividends. Rights regarding capital and dividends. Number 4, particulars of officers of the company. Particulars of officers of the company. Number 5 is minimum amount of subscription. Minimum amount of subscription and the amount payable. Minimum amount of subscription and the amount payable. One is time of opening of subscription lists. Time of opening of subscription lists. Another one is preliminary expenses incurred. Preliminary expenses incurred. Another one is particulars regarding purchase of shares. Particulars regarding purchase of shares. Another one is details of any premium. Details of any premium or underwriting commissions. Details of any premium or underwriting commissions. Underwriting commission is there are some fellows like what we have seen in the financial institutions. They buy on your behalf, or they buy from you, they pay you, then they go to sell. You see now they are taking that risk that people may not buy. And also they're giving you an advantage of accessing money earlier. So because of those two things, you pay them a commission. That's what we are calling underwriting commission. Number 9, particulars of reserves. Particulars of reserves. Number 11 is details of auditors. Details of auditors. Another one is audited report for the last 5 years. Audited report for the last 5 years. And the last one is any restrictions on members of at company meetings. At company meetings. So those are the items that you find in prospectus. It is usually a big booklet, so it contains a lot of information. It's a book, it's an entire booklet that contains all this. Let's now look at legal requirements. The legal requirements. Legal requirements of a prospectus. Legal requirements of a prospectus. One, it can only be issued after incorporation. Can only be issued after incorporation. Number 2, it must be dated. It must be dated. Number 3, it must contain the prescribed contents. It must contain the prescribed contents. Number 4, it must be signed by every director. It must be signed by every director. Number 5 is every application form must have a copy of the prospectus. Every application form must have a copy of the prospectus. So what this means is that you cannot issue a prospectus before the company is incorporated. Anything like that is not important. It must be dated. It must have specific time. It must contain all the 12 items that we have mentioned, the prescribed. And it must be signed by each and every director. There's not a few directors who are issuing, no. And every application form must contain a prospectus. The meaning of that, or the implication of that, is that every single person who desires to apply must have access to the prospectus. So it is not just be available to a few guys. No, it is every person desires to apply. Let's now look at liability for an untrue prospectus. Liability for an untrue prospectus. Liability for an untrue. The prospectus is not true. Who is liable? And we begin by writing untrue statements. Untrue statements is a statement which is misleading. Is a statement which is misleading in form and context. In form and context. And is included in the prospectus. And is included in the prospectus. Stop. There are two types. One, an innocent misrepresentation. And we explain, this is the one made honestly. This is the one made honestly, believing that it is true. It is made honestly, believing that it is true. That's called innocent misrepresentation. Number 2 is fraudulent misrepresentation. Fraudulent misrepresentation. And we explain that this is made knowingly. This is made knowingly or carelessly. Without belief that it is true. Without belief that it is true. Okay, then down there we write that the following persons are liable. The following persons are liable. One, directors. One is directors. Number 2, promoters. And number 3, issuers of the prospectus. Then down there we write that there are three types of liability. There are three types of liability. One is civil liability. Civil liability, and like that. This is where the persons liable must compensate for any loss or damage. Must compensate for any loss or damage suffered. However, they can have the following defenses. They can have the following defenses. One, the statement was immaterial. The statement was immaterial. And number two, they had reasonable grounds to believe that it was true. They had reasonable grounds to believe that it was true. So civil is where now a person is held liable, and we are told they will be called upon today. But you can go and argue that the mistake I did was immaterial, it's too small. And you can also argue that I did not know. You can take the defense of innocent misrepresentation. Number two, criminal liability. Criminal liability. Criminal liability. And write that this is where the one who authorized issue of the prospectus is punishable with 7 years imprisonment. Is punishable with 7 years imprisonment or a 10 million fine. 10 million fine or both. Or both. The company is also fined shillings 30 million. Company is also fined shillings 30 million. Yeah, so that is when you have criminal liability, you are fined 10 million, ama jela miaka 7, ama both, and the company is charged 30 million. Number 3 is liability under the law of fraud. Liability under the law of fraud. And we write that the aggrieved shareholder can reside the contract. Can reside the contract and seek full compensation. And seek full compensation. Seek full compensation, but must prove the following. But must prove the following. One, there was a fraudulent. There was a fraudulent misstatement. There was a fraudulent misstatement. Number two, misrepresentation related to material facts.